talk not from the top of my head, but from the bottom of my heart. I have observed, been involved in, have engaged with, have been part of the conversations, have been part of the standard setting for insolvency industry now for over 30 years. It was my engagement with the insolvencies, law, practice, global developments, global principles, all that started um, in the mid 90s when I started consulting for the World Bank and then for the IMF, and then through various other opportunities that happened on the way, consulted with the OECD, Asian Development Bank, and I've been deeply involved, in particular after the Asian financial crisis. And one thing that I learned in my exposure, even before the IBC was enacted, was very clear that insolvency law sits at the heart of financial architecture of any country, any country. Even some of the most formidable economies in the world, like US, like UK, um, China, elsewhere, it sort of retains a kind of a center stage in the thought process of economists, policymakers, and even the legal profession. And of course, other stakeholders, not to mention the judges, the regulators, and the industry itself. The second thing that I learned was that insolvency profession is one of the most reputed profession in the world. It is considered to be, if you can just give me a second, I'm just trying to now, just give me a second, I'm just going to put at least the opening slide for you to be there, because as I make this comment, so just if you can give me 20 seconds to sort of bring it around. So can you see the slides on the screen, please? If you can, somebody, if any of you can just mention so that I know.
Yes, sir.
Okay, very well. Thank you so much. So I found that not only is one of the most reputed professions, but in a much greater demand than even the profession of law. It is very rewarding, and some of the big firms around the world, their largest departments is insolvency and restructuring practice. And lawyers, accountants, why they compete to get into bigger firms in their insolvency departments. And like the legal profession and the CA profession, it continues to sort of compete alongside to be ranked amongst the top 10, 15 professions in the world, including, of course, I'm going beyond the law and economy now, and I'm looking at even doctors, economists, and others. So that is the importance, and that is the kind of sophistication that this profession has attached to it. And I always had a dream that why can't India have a profession like this. And when I got the first opportunity to raise this issue, I did not miss the opportunity. And that happened when, and there is the reason why I'm telling you all this. I'm telling you this because of the high expectations and the bar, the standards that we always had from this profession from the beginning, and not just from 2014 or 16, 2014 when the BLRC was set up, or 2016 when the law was passed, even much before that. When Dr. Manmohan Singh constituted a committee headed by late J.J. Irani, who was the director of the Tata Sons, to head a committee on reforms in the Companies Act. That was just after India had opened its economy for globalization. Economic legal reforms massively were being introduced in the early 90s. And the focus was to create ease of business, invite more and more investors into the country. And as a part of the overall improvement in the doing business ecosystem, a number of reforms were being introduced. And it was also decided to do the same for the Companies Act from a corporate governance point of view, from other reforms in the corporate regime. And then J.J. Rani was appointed on this committee to head it. And of course, we had very eminent other people from the industry, from the legal profession, and others on the committee as well. And that's was the time when I met Mr. Premchand Gupta. He was the Minister of Corporate Affairs. For the first time in the history of independent India, Ministry of Corporate Affairs was created as a first standalone ministry. Earlier, it was always considered to be a department of the Ministry of Corporate Affairs, Ministry of Finance. But Mr. Premchand Gupta was the first full-fledged Union Cabinet Minister with the Ministry of Corporate Affairs under his portfolio. I met him. There was a delegation of INSOL International. We were meeting various stakeholders. I was not the president of INSOL then. I was just a board member. And I explained to him about the importance of insolvency law in the ongoing reforms. And I told him that, many business around the world who are looking at India, they come to us as law firms and want due diligence to be done. And one of the key questions they want to know is what happens if the business goes into distress? What is the provisions of insolvency law and what are the provisions of liquidation or even restructuring for that matter? And when we used to tell them what we had at that point of time, the SICA, the SARFAISI, the Companies Act winding up, obviously they would be very, very discouraged to invest in India given the high risks that they saw. And I explained to Mr. Premchand Gupta, who was himself a businessman, and he understood. And he met the Prime Minister, Dr. Manmohan Singh, and he persuaded Dr. Manmohan Singh that we should amend the terms of reference of the committee and include insolvency law reform also as a part of that. And I was inducted in the committee. And we came out with a bill. The bill was tabled in the parliament in the UPA first term. But because of the Satyam fraud, a JPC was constituted, and JPC recommended that their recommendation should be taken up by the Irani committee to look to and review their recommendations. The draft bill was sent back, and then UP2, we submitted the revised bill with new recommendations. And by the time the bill was passed by the parliament in 2013, the elections had already been announced. And therefore, although the bill was passed by the parliament, the president did not give assent. And when the Modi government was formed in 2014, BLRC was formed, and that bill was not given assent by the president. But if you take up that bill, if you go to the parliament website and take out the history of that bill, you will find that it was in that bill for the first time the insolvency profession was proposed. And why I mentioned this to you was that the whole importance of insolvency profession, even before that, in Irani committee had mentioned a little bit, but not in a great detail, but Irani committee recommendations, we had much more detailed uh, kind of a framework that was proposed for creating an independent standalone profession of insolvency professionals. And it was also proposed in that there should be a self-regulation mechanism. And so serious was the government that at that point in time, it was decided to follow the UK model, and even a self-regulatory body was set up. Many of you may not be aware of that. That responsibility was given to me, and we set up Society of Insolvency Practitioners of India, which was meant to be a UK kind of a model, which has the IPA, Insolvency Practitioners Association. And the whole model was that Society of Insolvency Practitioners will be the membership body of IPs. Like currently you have the 3 IPAs, and they will have mandate from the Ministry of Corporate Affairs how to regulate. Uh, but obviously, because BLRC adopted a different model, so that Society of Insolvency Practitioners, which was registered as a society by the Ministry of Corporate Affairs, was then converted into a think tank. And Mr. Chindyok was made the first president. And then, of course, we set it up. It still exists, but because it was a society, we found it very difficult to use it as a think tank. And therefore, later on, insolvency law academy was created as a think tank. But I'm not going into that. That's not the purpose of the discussion. What I really wanted to tell you was that insolvency professional as a phenomena has been in the mind space of the policymakers for a very long time. And I also wanted to emphasize as to how much hard work had gone into, even before BLRC, into bringing a standalone profession of insolvency. This shows how important this area of practice is, first of all, in terms of this historical importance. The second thing which I wanted to mention was that when the law was passed, when the IP regulations were framed, and they were notified, made of NCLT, IBBI came into being on 1st October 2016. NCLTs were notified as adjudicating authority from 1st December. Regulations, CRP and liquidation were notified, and IPs started getting licensed. One of the key areas of discussion at IBBI and the Ministry of Corporate Affairs was how to build one of the most reputed and top quality insolvency profession in the country. And this discussion was very, very important because the government had taken a leap of faith for the first time to give this great responsibility to the private sector, while in the past it had always been with the liquidators. And there was a lot of lobbying and resistance from within the government sector as to how can you trust professionals with such important tasks where they will be managing large enterprises going concerns. There'll be great responsibility on them. And would they be able to live up to the trust or not? And therefore, it was discussed in detail, and we wanted to put together a strategy to make sure that the insolvency professional is built in the right way and does not let down the policymakers and those, including I and many others, who advocated in favor of the private sector insolvency professionals. We witnessed many, many tense moments of discussions with people who were opposing it. This again I mentioned because I wanted to bring out very clearly how greater is the responsibility on this profession when it comes to you living up to the expectations of the market and the regulators and the policymakers. And there's a great scrutiny on a daily basis on your conduct. Another reason that I wanted to mention as a background, and again, it's very, very important, is that we were very clear right in the beginning that it is the first 2 3 years and the first few cases which will determine the path that this profession will take. And therefore, the stakeholders, including the bankers, want to make sure that in the first few cases, the insolvency professionals who were appointed were largely from bigger firms like Ernst& Young, KPMG, Grant Thornton, Deloitte, PricewaterhouseCoopers, principally because those people had offices abroad and they could export knowledge. Two, they were doing a big amount of restructuring even otherwise. They were familiar names with the bankers, and they had huge reputational risk because if something goes wrong, the brand gets affected not just in the country but abroad as well. And also, of course, the whole idea was that you, in the first few cases, set the bar very high, and that is why, even though many professionals from the community of insolvency professionals who had been licensed were very concerned that why the Indians local smaller firms are not getting that kind of opportunity, but this was the reason why this was done. The other reason that I want to tell you, and all this I'm telling you because I just want you to know the scale of thinking that has gone behind in developing this profession. The other important aspect was that the conduct of the first few would determine how regulated or relaxed the profession would be. I had advocated in favor of self-regulation, and that is why even the Society of Insolvency Practitioners as a self-regulatory model was set up. But when BLRC obviously came in, they said, no, we need to have a regulated profession because the stakes are too high, understandably. But I still, when the regulations were being framed, was one of the advocates of less regulation and more self-regulation. There were many who said, no, in India, it won't work. We are doing a cultural shift. It was not as much of a reflection on the integrity of the people who will join the profession. It was more about making incremental changes and testing the waters rather than just jumping into it um, and take the blind leap of faith. So when this discussion was being held, it was decided that, okay, let us make it regulatory to the extent it is a basic minimum necessity. And if the profession behaves well, we will continue to stay that way. But if they don't, then we'll tighten it. And if they set high standards and bar of self-regulation by self-conduct, self-regulation, self-voluntary code of conduct, then even it can be relaxed further. And any of you, I don't know whether you had the opportunity to attend at least about 40 to 50 uh, training, motivational classes that I took in the first 6 months. And there were about 150, 200 all over the country, often 3 in a day as well. I emphasize one point only. It is you as a professional who will determine how regulated you will get or how relaxed the regulation will be. It is your conduct, how you perform yourself will determine. And if you'll not give an opportunity to the regulator, then the regulation will not get tightened as it has got today. And I also said that even if it was a handful of people out of the insolvency professionals who did not live up to the expectations, it will affect the entire basket of insolvency profession. Because the cost of that will have to be paid by all across. even if there are 10, 15, 20, 30, or 50 people, the other thousands which are registered, licensed, will have to pay the cost of it. And you have seen that happening today. Now, last point I want to make before I get into the actual topic, because this will give you the context for that as well, is that we also simultaneously wanted to build the profession from the beginning on the sides. And that is why graduate insolvency program now, which is postgraduate insolvency program, was created, where Dr. Sao gave me the responsibility. The chief economic advisor to the Prime Minister, Dr. Sahu, Mr. Mohandas Pai, and Mr. Ramesh Kumar, who was the head of the Deloitte. 4 or 5 of us got together and created this program. And then I was given the responsibility to be the first director, founding course director of this program at the Ministry of Corporate Affairs, Indian Institute of Corporate Affairs, and the Ministry of Corporate Affairs. And we were very clear that insolvency professionals should be trained to acquire or polish the special skills and nuances of the insolvency profession, or what the profession demands. And that profession today, that course today has become very popular. All the people who have come out of that course have gone into the best of the institutions. Some of them may be working with you as well and getting paid very well. And therefore, there is another vertical of profession that is coming out, which is completely fresh, new, and cultivated in a way that we always wanted to. And some of what I'm going to talk about is what we had always thought as a part of the development of the postgraduate insolvency course. And of course, other thinking that we've had at the IBPI government level, and also my international experience. Now, it is in this background I will now narrow down to the topic for the day. And in my first few slides, I will talk about the general skills required. I may have 1 or 2, 3 slides on the subtopic as IPs as a lawyer, but I will give reference to that even in the first few slides, not that I leave it to the end, because any which ways I'm trained to think and talk as a lawyer. So therefore, anything that I tell you would actually any which ways contain those shades of thinking through the hat of a lawyer, if I may say. And then, of course, we will leave some time for Q&A as well. Although I like to wrap up at least half an hour to 45 minutes a bit earlier, because it'll be difficult for me to spare 3 hours, and I have another lecture to give to Goa University, the Bar Council of India University today. Now, I'm sure, in 7 years since the IBC was operationalized, you know one thing very clearly, that this profession, and not just the insolvency profession, but rather all the stakeholders that are involved in the ecosystem of insolvency resolution or liquidation, require skills, and very diverse skills. And often, one stakeholder may require multiple skills. So we have committee of creators who are not just financial experts in the area of banking, credit, restructuring, but also they are aware of the economic ecosystem, because when you do lending, you need to know which sector in the economy is growing, which is not growing, where the returns are expected to be, where the risks are. So therefore, they have those kind of multiple skills in their own way. And obviously, very sophistication of insolvency and restructuring is something they've been learning on the way. Similarly, lawyers, even lawyers have multiple skills as advisors to COCs, advisors to resolution applicants, advisors to IPs. But again, lawyers also have multiple skills. Their skills are not just of ability to do advocacy in court or advise the IP, but also to understand the principles of insolvency law, to understand the economic rationale, to understand uh, how to handle a complex legal dispute, how to uh, discuss and negotiate. These are various skills that lawyers have, which they make use of. Some in a very specific, obvious way, but some probably in a very subtle, nuanced way, which you do not notice because they're so omnipresent and happen every day in that sense. But then it is the insolvency profession or the insolvency professional who is expected to have not just diverse but very polished skills. And those skills have to be multiple, but also of the highest levels. And this range of skills is expected because of the IP, because the IP is tasked with the most complex responsibility and functions in the insolvency process. You are expected to, as the first thing, um, stabilize the business that you have inherited, or if you've been given the task to run as a going concern. I'm not talking about the claims, settlement, promoter management, employees management, managing others, so many stakeholders, electricity department, this department, government, statutory authorities, security issues, all that. Of course, we all understand that. But I'm talking of the larger uh, headline items, stabilizing the business. Second headline item, to be able to engage with the employees and the workmen, which can often run into thousands in number, and give them that confidence that you have the best man to take care of their interest. And this is how you propose to run the process, and that there is light at the end of the tunnel. So don't give up, don't give in, and continue to cooperate and promote. You need skills of multitasking because there are so many things that need to be done. You need to show leadership skills. I mean, there are so many diverse skills, and I'll talk about each of them as we go forward. And why these skills are important more than the skills of anybody else as a stakeholder is because your decisions on a daily basis and how you conduct yourself impacts the quality of the whole process and impacts the outcome also. And the outcome of the process based on depending on your quality of skills can be a huge cost, not just to individuals who are part of that insolvency part as a stakeholder. If they're employees and workmen, then you're talking of the livelihood, their livelihood. But if you are looking at lenders, it is about their recovery, maximizing the value of their assets. If you're looking at getting some dues for the statutory creditors, you're looking at public money, taxpayers' money, because all that is a cost to the taxpayer. And then, of course, if the enterprise doesn't get back on its feet, there is a cost to the economy, cost to the GDP. All this comes in the or from the or through the hands of the insolvency profession. That is the uh, magnitude of the importance of the role of insolvency professional, and therefore the skills, the qualities, the abilities that an insolvency professional needs. And that is why this topic. Now, I haven't had the chance to discuss with the ICSA why this subtopic as an advocate, because I think this comes, I'm just guesstimating, comes from perhaps two, three concerns. Uh, First could be the over dependence on the legal profession. Uh, and I'll tell you why as I go on the way, because I'm still on the first slide. I'm just touching not even scratching the surface. I'm just touching the points to set the context. But one, it could be that the over dependence on lawyers. Two, it could be cost. And three, also about delegating a lot of functions which IP could himself or herself do, or itself also, if you're looking at IPEs. So these could be the reasons, but I do not know. I am only sort of, uh, making a wild guess based on my own learnings and observations, often some discussions with the people in the power as to what concerns they come with. And I have no hesitation in saying that it's an alarming concern. I, being a lawyer myself, I'm briefed by stakeholders to appear every day in courts, and I see, and I'm totally convinced that lawyers play a very important role in the insolvency process, not just in developing the jurisprudence, but also in terms of resolving the insolvency profession, including enhancing the quality of the process and outcome. But at the same point of time, there is a cost associated with it, and often that cost can sometimes be very prohibitive and can impact the overall cost of the insolvency process. And if it is disproportionate to the outcome, it can red flag itself for the lenders in particular who have to really part with it, especially when the costs are not coming through the cash flows of the copy data. And they then discuss it uh, in a way that why go to IBC then? And often also then, they start cutting corners and you end up with lawyers who are willing to charge less fee, but are not able to add to the quality, which means that if something with a good lawyer you're able to do in 3 hearings, you end up doing in 10 hearings, which means the cost of the 7 additional hearings work out to be probably greater than what the cost of 3 would be, given that there are a lot of intangible costs also associated with delay and with adjournments, and also because of the disruption that will be caused because of lack of quality of advice that comes. But having said that, there is absolutely no doubt that it is a matter of concern and we need to address this issue as well. Now, I think one central message that comes out of my understanding of the insolvency profession, and I'm sure of yours also over the last 7 years, that insolvency profession in itself is an institution. Even as an individual or a handful of 10 people, or whether it is 70 people in an organization, every IP in himself or herself is an institution. And he or she is expected to conduct, behave, function, perform, and believe himself or herself to be one. You cannot undermine or underscore not the importance of how this profession is a collective skills which are bundled or expected to be bundled into one person and a professional. And I purposely distinguish the person from the professional to say that the skills that are required are often skills that you expect in a person, but to be used while discharging the professional responsibilities. At the end of the day, a professional is a person, a human being, not a machine. And whatever he does is based on what he learns and what he thinks and believes based on his value systems, based on his training, based on the ecosystem that he has grown up in as a person, as a professional, what he's learned, and who that person is surrounded by, what that person's relationships have been in individual life, what that person's psychology is, temperament is, and what his philosophy of life is, or his or her. These are personal traits. But when you start, that person acts as a professional in any profession, these traits do have a dominating effect on how that person conducts as a professional. Howsoever professional that person might be, they do have a bearing, they do have a weightage, they do have a tremendous amount of influence, if I may say. And that is why I clearly see the skill sets as being divided into those that are personal and those that are professional, and bundled together, combined together, they become institutional. And also, of course, there are other factors. These are the factors of who you work with, who has mentored you, who are your juniors, who are your colleagues, all of them also who you discuss with, deliberate with, talk to, or consult. Also, of course, become a part of your thought process, your decision making machinery, and as a result of that, they're bound to have their own influences. And therefore, these advisors are also part of the institution in that sense. So, from my point of view, therefore, I have no doubt whatsoever that the insult that uh, the insolvency professional is an institution, which also, in fact, only re-emphasize the point that I made in the first 30 minutes, how important this profession is. I made this point, which is on my second bullet, about the reputation. I made it in a very, very subtle way, um, more in terms of the conduct of the initial set of professionals, or even now. But I have to tell you that there are two most important traits that clients, regulator, market looks at when they are wanting to identify an insolvency professional for anything: reputation and reputation. Reputation of the insolvency professional will determine nearly everything about him: integrity, track record, respect that person has, knowledge, and abilities, skills. Everything is compressed into one word, which is the reputation. If you have the reputation, and if you have built a reputation, and reputation, of course, I'm talking the good sense, which means that you have all that it needs to make a reputation, then It will always walk ahead of you. You will never even have to utter a word to tell you us to anybody who you are, what your background is, what your track record is, and whether a client can trust you or not with howsoever big a case. They may acquire, they may ask about your skill, whether you've handled a steel sector, whether you've handled a real estate sector, what is your experience in that sector, what kind of people you have. They may ask you about those kind of details, but they will never, even for a moment doubt your integrity, your capability, your leadership, your ability to deliver, and everything that it takes to be an exalted professional, which has helped you build that reputation. And they will come back to you again and again, again and again, because everybody wants the best service provider. Everybody wants to trust the best in the market, and everybody is also willing to pay the best. So, reputation is something which is the key. And I have to tell you this, this is something may sound a bit immodest when I tell you this, but I've now been in the legal profession for nearly 3 decades. And in the last 7 years is the only time when I've really, or if I had the opportunity to reap the fruits of all the hard work of over 22 years of bringing attention of insolvency law to the policymakers, helping it stand on its feet, capacity building, training, education, development of jurisprudence, sitting on hundreds of committees of my professional time uh, to build the industry in the country, ecosystem in the country, the systems, high standards, advocating globally for India. And I could have actually left everything else and now last 7 years only focused on earning the money. But for me, one thing is very important, that all the reputation that I have for the last 24 years, 25 years should not get compromised. And in fact, will get tested only now when we have the insolvency law, which is operational, which offers hundreds of opportunities, where I could have actually been in every case and in almost every case which was initially brought into the IBC. I'm talking the big dirty dozen. I'm talking of the remaining 20 odd cases that had come in. I had offers or opportunities to advise on almost everyone because everybody wanted me. I was the only experienced person that in the country at that point in time, but I said no. I can't monopolize. Number two, I will not be able to deliver as much, and why should I just get greedy? Number three, I also, my responsibility is also to mentor and therefore have other people come in and help in whatever way. And even till date, I just take, but I make sure that I do not accept cases where I have to argue anything which is fundamentally opposed to the IBC policy or law, and uh, always follow the principles of IBC. And most of them, which I'm going to talk about, I endeavor to. And it takes a huge amount of sacrifice, both financial and other opportunities that come your way. You have to weigh which is what goes with your reputation or which is what may compromise your reputation, and then take a decision. There's a huge sacrifice and cost that you pay for that financial, but that's a choice that you make if you believe that reputation is something. Reputation is what matters, and therefore today I uh, would like to believe that I have been able to live up to the expectations of my reputation. And it takes time. It doesn't happen in 7 years, but you have to start that journey on the day one, and you have to continue to walk the straight path. You can't deviate. Once you've deviated, coming back and regaining the reputation becomes absolutely impossible. So therefore, guard it with life. Guard it with your life is the message which I have on the reputation. Now, this is the, if I may say, the context and the background. And now, when it comes to skills, although it's more about the character that I'm talking about rather than the skills so far, But I think it's very important, and I didn't have too many words on this slide, only two words, because I just wanted the entire attention on these two words: the integrity and good faith. These are two fundamental uh, grains of what makes the IBC insolvency profession. Everything else can be learned, everything can be developed, everything can happen on the way. But integrity has to be impeccable, unwavering, and uncompromising. And integrity and good faith, if I may explain, is not set in the principles which are inflexible. So, for example, when we talk of integrity, it doesn't mean that the day you take over the company, um, and the promoter comes and meets you and he says, I feel very uncomfortable talking to you here. This was my enterprise till yesterday. Today you've taken it over. There are a number of my employees here. Can we meet outside over lunch? I'm happy to talk to you. I'm happy to cooperate with you. But can we just meet outside rather than uh, be in the office? Now, that's a very big judgmental call that you have to take. Your one instinct tells you you shouldn't be seen to be with the promoter outside. You shouldn't really be going out for lunch with him. You're the boss, you should take him. And then there is one side of you which will tell you, what's the harm? Thinking from his shoes, he's right. He's not very comfortable talking. I will not be able to get the best out of him in terms of information and everything. And therefore, there's no harm in meeting outside. Now, when you're doing that, you're doing it in good faith. So as long as you're acting in good faith, it's fine. And I give you just one example. There could be hundreds of such examples. So, good faith means that you are not in any manner acting in the interest of your own self over and above your duties. So, therefore, the good faith in this is that you thought it fit and proper, that you should meet him outside because of the reason that you believe that if you meet him outside, he'll be more open, he'll cooperate more, he'll be more hesitant here, he'll be egoistic. And I have to appreciate, I have to take work out of him. I need information more than anything. So, what's the harm if I meet him outside? But yes, of course, you will take care of some of the things that you will not let him pay. You should not pay for the lunch because you're not on his hospitality. And you should meet him somewhere open, in an open restaurant where anybody can even click a picture, but then so what? I met him because of this reason, and I met him openly. And I met him openly because I had no fear or hesitation of anybody watching me. I didn't meet him in the closed doors of a room anywhere because I'm not negotiating in a deal with him. So that confidence obviously comes over a period of time when you built a reputation also. But at the same point of time, what I'm saying is that integrity doesn't mean that you have to carry a chip on your shoulders all the time. Integrity means that you are acting in good faith. You are acting in the interest of the enterprise, in advancing your objectives of the code, and in advancing your functions by playing by the rules and not doing anything which will be uh, not just wrong, but appear to be wrong. Uh, there are so many other examples that one can give on this, but I don't want to spend too much time on this. I just wanted to tell you that for the foundation of an insolvency professional is the reputation. And the first building block on that, or the pillars on which your entire edifice will rest, your entire career will rest, is going to be your integrity. Reputation is the foundation. Pillars, columns are the integrity on which you will build your entire career. These are therefore things, and your only mantra is good faith. Anything that you have done in good faith, coupled with your reputation, will protect you. It'll be like a kavach. It'll be like a protecting gear, which will always protect you and save you from the regulator and from any other wanting person or party or wanting to harm you. So this is fundamental. Um, I will not spend too much time on this. We all know that you need to have knowledge. You have to have 360-degree importance. But I want you to know only two things on this, which is a part of the skill set. You have to have complete understanding of the ecosystem of the insolvency law. And insolvency law has an ecosystem which goes beyond just the IBC as a code or the regulations or maybe some of the other laws which are relevant to the sector in which that insolvency is happening. You need to know the economy of the country. You need to know the developments that are happening around the world. You need to know how those developments might impact the sector that you are advising that enterprise on. You may need to know this for also to understand how it might impact even the outcome of your resolution if the resolution plans are in the process or whatever. And I'll give you an example here. So if you know that the geopolitical developments that have happened lately in the last 8 to 10 years, including the Ukraine Russia war, some of the tensions in the Middle East, in the Gaza region, the tension between US and China. And can you just give me a second? I need to take some urgent instructions, please. Just one second. So now, if supposedly there is a company that you're advising which is exporting traditionally or importing to China, you know that you are in for difficult times. Or if it is Russia, then you know the economic sanctions as to how they are going to impact. Oil price are affected, which means the costs go up significantly. If there are enterprises that do business with you, which themselves are going financially bad because of these reasons, you know how that is going to impact your outcome as a going concern or your resolution. So, therefore, your knowledge development is not just confined to looking at your immediate vicinity of insolvency laws and regulations or what is happening in the country itself in the securities market or the various manufacturing sectors or the other or the tax policies, etc., but also beyond. Keep an open eye, especially because India's economy is integrating with the global economy very, very rapidly. And not just because of the outcomes of your cases, but also in terms of how the IBC functions, IBC results as a law, and how the profession conducts and behaves. All this will have a great bearing on the outcome of cases and the insolvency industry. And therefore, it is very, very important to keep an eye and to adapt to the changing times, to be able to take those factors and learnings into your decision making and make sure that uh, you are able to apply those current developments or futuristic developments into your decision making in order to absorb the shocks or reduce the cost or produce the best outcome. This is very, very important because, again, your decision is not going to impact you or impact only you. It will impact nearly all the stakeholders that I mentioned in my opening comments on how they eventually benefit or suffer from your decision making. So, knowledge and understanding is not just to be of the IBC, it has to be diplomacy, international experience, and also, if I may say, to a very large extent, also the cultural developments that are happening, the social developments that are happening, because those also will have a great bearing on how you have to act and perform. Uh, like, for example, if I may just give an example of how the sexual harassment cases are dealt with, what are the developments there, how the rights of transgenders are being decided globally or by the Indian courts, because you may have to deal with those situations in your enterprise or at your workplace. So, this is not just looking at IBC from a narrow prism. Have a wider, open eye on the developments around you, social, cultural, economic, political, because all of them have a bearing. And that is why insolvency profession is very different from other professions, because they have an interplay also. And similarly, of course, the other laws that are being amended or changed or jurisprudence that is coming in, whether it's contract law, personal law, criminal procedure code, Indian penal code, whether it's the Negotiable Instruments Act, all those changes that are happening, you should be aware so that uh, you don't have to necessarily draw a blank on these issues and rely on advocate only. Have basic general understanding of uh, all the legal principles, legal laws, developments, jurisprudence. You don't need to be expert on everything. You don't need to know everything as in detail, but you need to have a familiarity. And that familiarity is very important, because even when a lawyer that you hire to advise you on complex issues, he comes back with an advice and communicates to you, it's easier for you to understand, it's easier for you to know, it's easier for you to discuss, it's easier for you to take a decision. It's so important, because at the end of the day, it's your responsibility and not that lawyers opinion advice always carries a caveat that you will act on it on your own risk, and therefore the risk is yours. You will never be able to take this defense that you were advised by a lawyer. That defense doesn't work if you have taken a wrong decision which has a consequence. And the only thing is that it may help in uh, reducing the quantum of punishment, only to show that you acted diligently, that you took advice. But um, that acting diligently is not enough. That ultimately, what decision is taken, that is the key. So, therefore, always have brush up your knowledge about other laws at the basic level, at least, so that you can understand the implications of the decision that you're going to take on the basis of the lawyer's advice, and you just don't blindly follow it. Ask questions, um, as many questions from your lawyers, and ensure that you get answers. And those answers are something which you apply your mind on, because a test ultimately for good faith is, did you apply your mind? Did you apply your independent mind? Did you question yourself? Did you read the document carefully? And if you read, did it not in any manner challenge you anywhere to ask any question, etc.? So this is very, very important. Therefore, knowledge and understanding of law, economy, global developments, political, cultural, social events and developments, as to how they will impact, and not only your decision making, but in terms of those who you rely on for advice, to how you will be able to assess the quality of their advice and take a decision basis that. Now, this is a very important thing, and I think this is one of the key reasons why we have we are ending up in a many ways in NCLTs, and why NCLTs are clogged with so many large number of applications filed on an everyday basis. Can I just get? I was thinking, uh, we've been now. It's been now almost 1 hour 45 minutes. Can we? Is any possibility that we can take a 10 minutes break? Anjali, are you there, Anjali? 5 minutes break. Okay, so maybe Anjali is not around, but maybe I'll take the liberty of about 5 to 7 minutes break, just the restroom break and water break, and then we'll come back again in 5 to 7 minutes.
Yes,
Thank you.
please.
Thank you. All right, I'm back. Um, I don't know if Anjali is there or not. I just wanted to let to know that I'm there.
Yes, sir, I'm here only.
Okay. So Anjali, is uh, is 3:54. I will continue till about 4:30, and then 15 minutes of Q&A we'll do. Okay. So now this is something which I believe is the soul of insolvency law. And we have unfortunately not paid much attention to it in the initial years. And as a result of that, we couldn't really build this narrative around insolvency law that it is a very non adversarial process. The, the word used in the law is resolution, and the resolution by its nature is conversational. It is something which is expected to be handled and cared by discussions and negotiations and by mutual understanding rather than taking up confrontationist position, adversarial position leading to litigation. Um, it is very, very important that the IPs decide everything in accordance with law, but even the decision making process has to be very by nature non-adversarial. You have to take parties into confidence. You have to talk to them. Even if you're deciding against them, you have to reason with them. You have to explain to them. You have to try and resolve the issue. You have to ensure that that to the extent possible, litigation is avoided. Obviously, I understand the IPs don't have full control on that. What the other party chooses to decide is their choice, and you can't control their decision making. But it is very important that your approach should be such that you should give confidence to the other party that you are actually genuinely concerned in resolving the issue. But your hands are tied wherever you are able to decide against. But wherever there is flexibility and possibility of resolving the issue, resolve. Um, it is the approach itself that matters a lot, whether it is in the court or whether it is outside the court. And this will really help in understanding that even though the regulations or law is the way they say, but at the end of the day, the objective of the code is something which is there in writing before you. And anything that you don't do in good faith, in lines of those objectives, you have to interpret the law. You have to try and apply the law in that spirit. That makes it non-adversarial. If you take uh, in your mind a position that we are two opposing parties and that we are deciding against each other, or we are contesting, or we are adversaries, then you start thinking from that point of view. And this is therefore very important, and that's why even the courts in NCLT are the bankruptcy courts are not called as courts. They're called as adjudicating authorities. They're adjudicating on issues, but they're not deciding disputes amongst the parties by nature. And therefore, they are not typical courts. And that is because the IBC by nature is non-adversarial, and that is why we need to make sure. So for example, mediation is a very important issue that can be used. Mediation has been used so far by the courts, also appointing some people to mediate on issues. Recently, one of my cases where there was some issue between the two uh, members of the consortium of resolution applicant, the court said, and that too after the implementation, the court said we can help you by getting a mediator, but we will not decide that issue because you're not able to sit together and resolve. So they've said that we'll probably get you a lawyer who can decide this issue for you, or maybe some other person who can actually just so that egos are not drawn into it and unnecessarily positions and battle lines are not drawn in that sense. And similarly, uh, you have to understand that even when lawyers advise you or you seek advice of the lawyers, you should always try and tell them that, look, I want to solve this issue. So tell me not just what is the legal position, but also tell me how I can resolve this, how I can close this, how I can settle this. Because whatever decisions you take or approach you decide, it has a direct bearing on the cost of the process. Adversarial approach leads to more litigation, leads to more costs, and leads to delays, and all this ends up giving a very bad optics to the whole insolvency process. And therefore, you should, in many ways, try to use your skills, your temperament to be the emotion, be the non-adversarial in your approach. Now, this is something which most of the time we don't talk about. And usually, as judges, when judges sit there, they're expected to only look at the law and interpret the law. They're not supposed to apply their public interest element or other aspects. That is how the justice operates. But as insolvency professionals, it's so important that you have, besides the knowledge development and the understanding, the integrity, honesty, and approach to insolvency resolution, and emotional quotient. The emotional intelligence is very important. And that comes in as a person, not as an insolvency professional. You have to be, in many ways, in your approach, empathic, and compassionate. Not at the cost of compromising the law, but to be understand and have the sensibilities and the sensitivity to understand the problems of the others, to understand the difficulties of the others or the situations they might be in. You have to understand uh, the problems not just from a pure and simple manager of the process or the enterprise, but also as someone, as a human being, because your people management, your ability to take people along, your ability to have closures to the issue, to your ability to have people have confidence in you, will come from the fact how they connect with you emotionally, how they feel that you have actually understood their problem and are empathetic and compassionate to what they're thinking. Even if you are helpless, your helplessness should be expressive in such a way that people believe that you're honest in that fact, and that honesty comes from the fact that you think as a human being as well, and not just as a professional. And how to draw a fine balance between emotional quotient and your intelligence quotient is a very important thing. You have to be emotionally intelligent, but you also have to be intelligent otherwise as a professional, and balance it in such a way where it sort of enhances the outcome of your actions, decisions, and your ability to communicate, your ability to connect with people, and ability to carry that positive energy to the people. And that energy should then carry across to the recipient um, a clear message that, oh, he's a well-meaning person. What he did was right. He was helpless. I don't need to be personally opposed to him. I don't need to um, hold it against him. I don't need to become in any manner an activist, a rebel. Even if I have to defend my law, my position as a person who has suffered from the decision of the IP, I'll keep it purely professional, and I'll not make it an agenda. I won't start filing complaints against the IP in the IBBI, even if I'm aggrieved. So these are the kind of things that happen, which are very important if you make use of your emotional quotient. This is something which you all know. I won't really spend too much time on this. That you have to act like a true leader, uh, and when you act like a true leader, it means that you have to take people along. You have to take firm decisions. You have to hold people along. You have to carry the meetings of the COC. You have to carry the meetings of the key managers. You have to think as a leader would. You have to identify the problems, challenges, solutions, everything, negotiate like a true leader. And when you're a leader, you have to take firm decisions, but that those firm decisions should not come across as perceived as something which you may call as arrogance or ego, because often the complaint that goes around the market is that some of the IPs, uh, when they come into the new enterprise, they take position, they uh, they are a bit close, and they're not able to sort of uh, gain the confidence of the stakeholders and the vendors and the others, the employees and management, because of the fact that they, as a leader, there is a distance that they maintain, and which come across as arrogance often. And this is very, very important because, but I'm sure you know this from last 7 years, how to manage it. And this is very personalized also. This is not general in that sense. This is again a very important issue. I touched upon it very briefly, that your entire approach has also to be not just non-adversarial, but as a therefore problem solver. Uh, and I'll give you some example there. We have um, there was so much of hue and cry when Vidarbha came and when Rainbow came. The entire market was cribbing. The lenders were cribbing. Everybody was saying, "Oh, we need an amendment. We need an amendment. First, we need a review. Then we need an amendment." Well, yes, of course. I mean, I think Rainbow did shake up the insolvency industry a little bit. But honestly, every judgment that comes, you can't demand a change in law or a regulation to undo that. You have only two ways to do it, to deal with that. If the policymakers want, they feel, they will do it any which ways. But the market can't wait for the law to be changed or the regulations to be changed. It takes time. Uh, Market has to find its own way and innovation around that. Market has to solve the problem that has come by innovating and experimenting. So I'll tell you, when Rainbow came, I read every single word of it, and I found that the hype, the euphoria, the whole noise that was created around Rainbow was very unwarranted. I did my research and I came up with a 20 pager. And I started arguing before NCLT to distinguish Rainbow. And I told them, look, Rainbow just holds that the Gujarat GST Act gave first charge to the GST authority there. But it doesn't say that just because that first charge is written in that law, the IP is expected to give them priority in charge. That is not what Rainbow says. Rainbow only says if there is a first charge recognized by a statute, you can't disregard that. Because notwithstanding or the non-obstante clause in the IBC doesn't override everything unless it is in contradiction. And I saw GST Act as not a contradiction at all. And my approach was, and thankfully now that is beginning to get clarified by NCLT, is very clear on the lines that I had said, which was, just to sum up a little bit, as a problem solver, that I said that, look, it is a well-established principle in law that a security interest can be created by operation of law, as in the case of GST Act, or it can be created by act of men, people, parties, which is the banker and the borrower. In either case, or in both the cases, the act of security interest creation has to be perfected. Only then it becomes enforceable. Or it gets recognition in terms of the priorities. And that is because under the Indian legal system and policy in 2011, a policy conscious choice was taken that the state dues, the sovereign debt, do not get priority as a matter of fiction of law anymore. They will have to compete with the private sector in terms of creation of security interest and in terms of priority of rules in particular. For the first time in 2011, SARFAESI Act was amended and a central registry was set up. Central registry rules were framed, and we moved to a notice giving registry system, which means that every lender who is seeking to create a charge on any asset is required to inform the public at large of the creation of that interest, security interest. And anybody who has not done that cannot claim priority, or will their priority will be subordinate to the one who has given public notice. And public notice is by the day and the hour. The rules say that. So, for example, coming back to the question in hand, if GST Act has created a security interest by way of statute in respect of that company, but if that, in the event of any disputes being pending or not being pending or whatever, that charge has not been filed with the CERSAI or by the company in the ROC, then that charge has not been perfected and will not be binding on the liquidator under Section 77 of the Companies Act. And in any case, under Section 53, it will not be given the priority, or the priority will be given to those who have a charge that is registered. So therefore, GST Act, just because there is a first charge, does not in any manner mean that the IP is recognizing that charge, unless that charge was filed with the Form B as an operational creditor who's secured, or if that charge documents were filed along with the charge certificate. Only then that charge gets priority along with the others in that manner. Now, in any case, I don't want to go into the details because it's not a rainbow lecture. How it has to be treated in liquidation and how vis-a-vis how it is to be treated in the CIRP. But now in 3 decisions in NCLT, the distinguishing has started happening. And also because everywhere the first charge is not mentioned, somewhere the charge is mentioned, like in the case of Greater Noida and things like that. And those orders have started to come. And you will find them on the NCLT website. So therefore, what I'm saying is that perhaps this is something that could have been done earlier rather than a panic being created. And I'm quite sure that over a period of the next 3 to 4 months, the jurisprudence will develop in such a manner that you will not even need an amendment to that extent. Because what a government statute does is the policy choice. The central government cannot say that, oh, state government of Gujarat should not give priority charge to the GSAT. That is not a call of the central government. Similarly, every state, every central, we are a constitution of India where there's a federal system. There we have 3 lists to our constitution on which central government or the state government can make lists, or both the central and the state government can make lists. So therefore, IBC cannot overdo what the state governments do. We need to find solutions by looking at the other applicable provisions. Now, I gave you that rather longish example to show that our approach has to be problem solver, and you IPs have such great, vibrant, robust groups, WhatsApp groups and other discussions where all the time you're discussing the problems and obviously, sharing with each other that is what needs to continue to go on in order to make sure. May I request all of you to please mute your mics because the mics are open and that is creating a bit of a disturbance. So that's the mantra of an insolvency professional, to identify challenges and find solutions. And these solutions always will come with some risks, some innovation, some experimentation. But as long as you are acting in good faith, you're acting in the interest of the enterprise, your conduct is substantiated, your action is substantiated by your conduct, corroborated with your intention, nobody can question even if your action goes wrong. And of course, you need to do some risk management and risk mitigation. But the point I'm making is that you just can't say, oh, I have a challenge and I just hang my boots. That it doesn't work that way. And find ideas, move forward, and continue to negotiate and navigate your way through these problems and challenges. Another important thing which I want to mention is the culture. The culture is something which is often underplayed as an importance in the overall functioning of the IBC. IBC is something which, if you go to the fundamental principles of insolvency law, it takes into factor the economic, cultural, humanitarian, and social aspects. One example of that is that in India, in Section 53, The workmen and employees' dues of particular period prior to CRP are treated as paru passu with the secured creditors. That is very unique in India and maybe in one or two other jurisdictions, and that is because India is a socialistic state to that extent. Workmen and employees' dues are considered to be very, very important, and therefore there is that kind of priority provided to them in the waterfall mechanism. Now, this is a social factor. It's also a human factor because people who will be rendered jobless, they should have enough to sustain themselves before they go and find another job. Their homes should not get impacted. Especially we know that workmen are low wages people, and so this is a social aspect. And from that arises also a cultural aspect. Now, cultural aspect also could be as simple as, and I'm oversimplifying, but it also means that one is an insolvency professional who is, let's say, I'm just giving an example from Punjab, who has been brought up and lived in Punjab and suddenly appointed as an insolvency professional of an enterprise in West Bengal or Orissa. Now, not only is the language different, but the culture is different. The culture is so different. Even global culture you need to understand. I'm not talking of within the country, because within the country itself is a subcontinent. We know there are so many cultures. But I'll give you an example. Let's say, for example, in, uh, when you sit in meetings, normally uh, when you're listening to someone and you nod, it is considered as as if you're acknowledging or even accepting or even admitting. It is seen to be an act of a yes, nodding the head. And nodding it sideways is always seen to be as something which means that you're in disagreement without saying the words. But for example, in Japan and many other cultures, even in India, nodding does not necessarily mean yes. Nodding is just mean that I'm listening. I'm hearing what you're saying. In Japan, for example. So therefore, you just therefore can't believe that just because that person sitting in front of you who's a Japanese SRA or a Japanese promoter, director, is agreeing with you. He will not. He's not necessarily agreeing with you. So these are the kind of nuances and understanding of the cultures that you need to know. Similarly, you also need to understand and know from the cultural point of view of how people behave and conduct. For example, that if there is a woman who is expecting, and how do you treat her differently from a woman who's a different woman in the room. Now these are very nuanced sensibilities that you need to have of the culture, of the sensibilities of the social and other factors, even religious factors, because these are very important in our case, and they can actually make people flare up. So it's very, very important to know them subtly and um, incorporate them in your behavior and conduct when you do it with them. I mean, if a person who is insolvency professional from Punjab, he will talk to his workman when he comes on the first day in a very different way uh, to what he's used to back home. But when you go to Bengal, if you behave the same way, they may just have their lathis and swords out. So you have to know, how to approach them, what is the words to be used, um, what word not to be used. Unless you understand the language fully, don't use that language, get an interpreter. Now these are the kind of things which I'm sure from your experience you already know, but these are factors that play a very important role in terms of how you will be perceived, how you will gain the cooperation of the people, and how will you now. And this actually is also something which my spills over to the next slide, which is about the interpersonal skills, people management, talking to your colleagues, gaining their confidence and respect, and that of the juniors and the seniors all, how you write your correspondence, to how you address people, um, how you respond to how people address you. All these are very, very important field. Needless to say that you need to have resources of all kinds. You should only take up what you're capable of delivering. Not every skill you have, and if you think that you need to add that skill, bring people in the team to make up for the gap. You can't be everything. And if you believe that there is one skill that somebody else is better than you in your team, use that person rather than try to do everything yourself, and make sure that you have the best of all as a part of the resource set that is available within you, both on the professional side and in the personal side. This I've already spoken to, but I just want to mention, actually, because I came in a bit of a rush. So these three bullets on the top should have actually gone in the initial slide, but I want to spend, last two bullets. From my experience of IPs in courts, I have three observations. One, I think that they don't normally they sign on dotted lines on what the lawyers write, and lawyers can often write long pleadings. They can go endlessly. They can write, repeat, be very very repetitive, and something that can be said in 4 pages can is runs into 100 pages. Or sometimes what deserves 100 pages, you don't write a summary, or at least don't give a synopsis, so that the judges get upset right at the beginning. How do you expect us to read 100 pages? So please be brief, precise, and request the lawyers to produce good summary, short summary, and file it in the top of the pleadings, or take it with you to the court. Always list of dates, synopsis, so that you can hand it over to the judges, or at least even file it beforehand as a top of the brief, so that the judges have the benefit of reading it. They will always appreciate IPs taking that effort, making that effort, and taking the pains to make their task a bit simpler, and not just passing on the burden the benches to read. This other point, second point that I wanted to make was that in terms of resolution plans, now by this time that every bench has some templates, or at least some benches have templates in which you have to give their summary. And it's so important that you file that summary on the day one with the resolution plan application. Otherwise, you take it from me that every time the matter will get adjourned, they will want you to file that. It happened to me today. 100% approved plan. Only one point was against us, which Supreme Court has decided in our favor last week. But I couldn't get the plan approved today because there was no summary. And they wanted a summary. And if that summary would have been there, we would have got the order reserved today. So uh, sometimes, I keep requesting also so many um, IPs, please do, but they rely on their team members for that, because IPs can't be doing everything. They rely on their juniors or their associates, and those associates just tend to be overburdened at times, or overlook the importance of this and file it on the last day when it is not on the uh, on the on the DRIS, or so this delays, of course, we all know. And the last thing which I want to mention, this was adjournments. This is something which has become a matter of great concern in the industry. Adjournments being sought by lawyers, adjournments being uh, given because the IPs are not prepared. And I'm not saying that the adjournments not happen because of the courts being overburdened and matters getting adjourned because your turn doesn't come. That is something which you can't help or control, but at least we should put our house in order and not give an opportunity to the NCLT judges or NCLET judges to complain that we are not doing our things enough. Only one more slide that I had was on uh, this particular issue, which is very dear to me. I do believe that your personality is not just about your profession, your conduct, your work. It is also about your persona and demeanor, how you dress up, how you conduct yourself in court, how well you present yourself in the meetings, how well dressed you are, how well groomed you are, your your from your hairstyle to how everything is combined together makes you a pleasant personality, or someone who doesn't fit into this space. When a judge will see an IP standing well dressed, demeaning, respectful, humble, his 50% of uh, thought process is in favor of the IP, because the energy that you are communicating, he knows that it looks to be a very nice guy, looks to be a well-meaning guy. 50, this thought in itself sort of reduces any question or anger or any affront that he may have on the IP. So please do not undermine the importance of personal development, grooming, presentation skills, ability to carry yourself. All these are very, very important as well. So I will pause here. This is a topic that I can speak for on days, but on any given day, anything more than this becomes a little too heavy. And also, we have other stuff to do. I have another lecture in about 20 minutes. So, if I may request Anjali, if we can open it to Q&A.
Yes, sir.
So Anjali, I was saying that why don't we just now move to the Q&A? So,
Yes, sir. Sure, sir. Sure.
hmm. So everyone, please feel free to ask any question that you might have, and I will do my best to answer. We can take about 10 to 15 minutes. Well, Anjali, it seems that there are none. So in that case, you might want to close.
Yes, sir. I think we should conclude now.
Yes,
Sir,
please.
sorry,
Yes,
sir.
No, please, please. Yes, please go ahead,
I'll put
Mr.
little-
Taliban. Yes, sir.
Thanks a lot, sir. So my question is around the Rainbow judgment, which you were highlighting during your presentation. The industry or IP should not make a huge and cry when this judgment come, and they have their own systems to ensure the mitigations or solution should be available. Can you explain again, because we also struggle with that judgment, and sometimes financial, especially departments, do come on us. Why are not considering as a par with financial creditors?
So sure, I'm happy to talk about that. But although of course this was just an example that I was giving of how you can find your way around. But if you want me to say a few words about the rainbow judgment, I'm happy to say that. So the rainbow judgment, what the rainbow judgment says is that in GST Act, the Gujarat GST Act, the Gujarat GST authority has first charge on the assets of the or the proceeds of the corporate data. Now, therefore, the Supreme Court said that you can't disregard that fact because that is a security interest created by the operation of law, by that statute. And you could not have disregarded that, and you had to give it a treatment in the resolution plan. Now, they did not say that, and they also said that, Section 53 doesn't say that you will not take into account those. But it doesn't say that just because that first charge is mentioned, the IP should make the payment or they should be given distribution over and above the charge which is held by the others. They also do not say in the judgment that just because the charge has been created, that charge can be enforced as a matter of fact without requiring any other action. It also doesn't say that the secure transactions principle or secure transaction law or other laws that come into being for creation, perfection, enforcement of charge, recognition of charge will also be disregarded. It doesn't say that GST Act doesn't have any authority or is exempted from the applicability of the other laws. That is the first thing that you need to be very sure after reading the judgment. It doesn't say so. Now, therefore, what it does is it says that first charge you can't disregard. Now, which I completely agree. How can you disregard? That is a charge that exists. And the IBC says that you will recognize priorities under Section 53. But in liquidation regulations, it is stated that liquidator will recognize the charge on the basis of CERSAI and ROC registrations.
Charge created.
That's the charge created there. Now that's it. But in the resolution process, regulations, it is silent. It is left to the COC under section 30 subsection 4 read with section 53 to decide the distribution.
Okay.
Right? And section 53 says you have to pay the payments in such a manner. Of course, there are secured creditors, then there are unsecured creditors, and then there are, others, and of course, that's the whole hierarchy. Now, what I'm saying is that Supreme Court judgment only recognizes and highlights what is a fact and what is there. But that does not mean that GST Act needs to be paid over and above other financial creditors of the corporate debtor whose charge may be registered with the ROC and CERSAI, and they may have first charge on the assets. Even
Correct.
if GST Act has a first charge and other creditors also have a first charge, then the creditors whose charge is registered with the ROC and CERSAI, they will be paid ahead. And the other will not be. And therefore, that is one. Secondly, of course, it will also have to be seen in the security creation documents of the bankers as to whether it recognizes this fact or not, that there are other charge creators, or even if there are other charge creators, this charge will prevail. Or if they recognize that charge, but maybe that is how it will be. So there are many documents I've seen of Greater Noida or Noida Authority where sometimes their charge is recognized by the financial creditors who are financing the project. So it is very dependent on transaction to transaction.
Correct,
Right?
sir. That is very clear in banking. Whenever they recognize any other financial creditor, they issue pari passu with them. If they share a
With
security,
them, or if you're giving a second charge also to somebody, you have to take NSC or the first charge holders.
first charge rule. Correct, sir.
Right? So these are the rules. Now, therefore, what I'm saying is that just because a charge is created by a statute, it does not mean that that charge holder will get superiority of charge alongside financial creditors, unless that charge is registered with the ROC. Whether it's the income tax authority, whether it is any other authority, they are also required to register their charge. There is no exemption in ROC or in CERSAI to any government authority for their charge being registered. Their charge will have to be registered. And in fact, there is a report in 2011 of MR Umarji Committee, of which I was a member. That report was written by me. That was a committee appointed by the Finance Ministry, basis which this amendment was made. CERSAI was set up, and all these amendments were made, where it is very clearly acknowledged that every authority who has a charge, even by whether by a statute or by an act of creation of a document, you have to register the charge, because we have moved as a country towards a notice giving registry system, which means every charge that is registered on any asset, the public has to be given notice of. Without that, you don't have any priority on that. But that doesn't mean that the charge is not there. Because you create security interest by way of documents, not by law. You create a mortgage deed, you create a hypothecation deed, you create a pledge, but you may not have registered it. You may not have paid a stamp duty on it. You may not have registered the charge, but that doesn't take away the creation of the charge, right? Or the security interest, which means that it is a defective security charge. So if you want to enforce it later on, you have to register the charge, you have to pay the stamp duty, you have to file the charge, and if you file the charge, you can never get priority ahead of those who have already registered the charge. You miss that bus. But yes, your charge will be registered. It can still be registered within 330 days under the Companies Act, 300 days or whatever after the 2019 amendment. So what I'm saying is that every problem has a solution. It may not be a perfect solution, but it is incremental progress. And when you make incremental progress, it sort of is like a foot in the door, and you can always shoulder your way in. So I'll stop here. Although, of course, Rainbow is something we can discuss more in detail at some point.
Sir,
Thanks a lot. Thanks for your input,
sir.
sir.
Only a brief, small question.
Sure. Yes,
sir. How now the courts are dealing with the claims of Greater Noida and Noida?
So if you see, there are 3 judgments of NCLT, Bench 2, Bench 3, Bench 5, which have come out in the last 1.5 months. If you will see those judgments. I don't remember the name of the judgments. And those judgments are now...
Dynapon is there. Yeah, I know.
Yeah. So they have now, first of all, started saying that Section 77 registration is not exempted. You have to. And in one of my cases recently, for Greater Noida, the bench 2 has recently said that based on that judgment of Rainbow, Greater Noida has to be recognized as secured operational creditor. But what it gets paid as a secured operational creditor will have to be decided by the COC and IP based on their status of registration of charge, what claim they filed, whether they need to get priority over above or not. That the court said, we will not go into that. We will only recognize them as a secured operational creditor because UP Development Act or Land Development Act says that they will have charge. So,
Right.
and when we found that, and I told the bench that if you want us to do that, we are quite happy, the liquidation value is zero. Because the financial creditors who charge as registered, they have a priority, they will get more. But the SRA was himself giving X amount of money. So the court, then I told the court that you please write in the order that whatever IP decides or whatever RA is already agreed to pay, whichever is higher. Otherwise, whatever SRA is giving, even that they will not be entitled to. So they understood that point. So in a way, therefore, we have got an order now where even as a secured operational creditor, the liquidation value is nil, but SRA on his own will has agreed to pay something because he has to do business with Greater Noida. He still has to get OCs. He still has to get some approvals. So he would like to pay something.
Yeah. Thanks, sir.
Any other question? Okay. Well, then in that case, Anjali, we can close it. And thank you so much for giving me the opportunity. And I hope you enjoyed. I know this is a topic which you hear day in, day out as a lecture from IBP and even otherwise. But I just wanted to share my perspective on this as well. So thank you so much.
Thanks a lot, sir.
Thank you.
It was indeed pleasure
Thank you so
listening
much.
you.
Thank you.